Mentioning.
Lordship, may I be permitted to mention two matters for inclusion in the list, Lordship?
I'm mentioning matter, Lordship, one matter. This I'm the tenant, one interim order WPO 1/2025 without giving any notice, without making party us. The order of demolition has been passed, interim order passed, and notice has been issued.
Is it a Group 9 matter?
It is the matter, original side matter, Lordship, PIL, P, WPO P.
Bill will not be before us. It will be before Justice.
This is what a notice pasted on our wall.
You see the determination.
I have your lordship's leave to mention two matters for admission arising out of Employees Compensation Act, my lord. Grateful.
My lord, may I be permitted to mention a matter for inclusion in the list?
It's a which group is it?
My lord,
you check up that.
I'll check it.
You verify which group and then see. See the determination we have got. If it is within our determination, you can give the letter.
Lordship, 8 number court is not sitting today, Lordship. 8 number court is not sitting today, Lordship. Kindly, if any order passed, we have to collect.
Some urgent, but nobody is informed us.
But someone, a special mentioning can be done. Yes. Obliged, Lords.
Original side daily list, item number 1.
Yes, what happened?
Well, yesterday at 10 o'clock in the night, we received a letter from the department.
See?
Interesting that they have now initiated the process of provision and release.
We have taken step, my lord.
My lord, we have already taken step, my lord, to release the goods, my lord.
When?
My lord, kindly. Yesterday, my lord, we have already written a letter to the, my lord,
correct. Mr. Banja has given us the copy of the letter. There's no problem.
My lord, kindly adjourn for fortnight, my lord. By that time, my lord, we shall do everything.
Fortnight? Why fortnight?
Then, my lord, 1 week, my lord. 1 week, my lord. Kindly adjourn for 1 week, my lord.
Next 1 week.
They're already in contempt.
No. My lord, now we are...
By Tuesday,
Tuesday.
My lord. Or wait, my lord, make it Wednesday, my lord. Instead of Tuesday, my lord. Wednesday, my lord.
Wednesday is a good day. We have heard. The learned senior standing counsel appearing for the department has placed copy of a letter addressed to the applicant dated 12/6/2025, signed by the Assistant Commissioner of Customs, Law Branch HQ, CC (P) West Bengal, stating that in compliance of the order passed by this court on 5/5/2025, the department has already initiated the process of provisional release of the goods. Let the matter appear under the same caption on 18th June. By then, the goods shall be provisionally released in terms of the directions issued.
Grateful.
Madam.
Yes, sir.
Item number 2 with 3.
For the respondents, my lord.
Your lordship, actually, item numbers 2 to 7 are all connected. Your matters, your lordship.
Mr. Khaitan is there.
I'm being led by Mr. JP Khaitan in the matter, your lordship.
So when do you want it?
We can start with your lordship. Your lordship had fixed the matter for hearing for today. He's on his way, your lordship. On his line. But if my lord may be pleased to take ITA 16, your lordship, because your lordship, the matters are all identical. And my lord, ITA 16 is the appeal. If I may give a brief background about the facts, and if my lord may allow me to hand over a short list of dates that we've prepared.
ITA 16, ITA 80,
235. We've prepared, your lordship, a list of dates for my lord's convenience.
My lord, I will reply on another day. आज नहीं possible.
Yes.
But I will reply on another day because I'll need some more.
If I may give a brief background about the facts, my lord, by taking my lords through the list of dates as well. My lord, the appellant and the petitioner before my lords is a Cricket Association of Bengal. My lord, they are the regional authority in charge of cricket. My lord, similar to my lord, the association in Tamil Nadu, the Tamil Nadu Cricket Association. It's a parallel body as that in West Bengal, my lord, Cricket Association of Bengal. My lord, in their case, my lord, in assessment, the assessment years before my lords are assessment years 13, 14, 14, 15, and 18, 19.
13, 14.
14, 15, and 18, 19. In when ITA 16, my lord, deals with assessment year 13, 14, and that the connected writ petition is WPO 1300, my lord.
One second. So ITA 16 will be taken as the lead case.
Yes, your lordship. W 13, 14. Your lordship, an assessment ITA 16, my lord, that is a case of reassessment. Assessment years 13, 14, and 14, 15 are instances of reassessment, whereas assessment year 18, 19 is that of a regular assessment. Your lordship.
ITA 16 of 23 is for assessment year 13, 14.
My lord,
It's
reassessment.
a 147 order.
Yes, your lordship.
Then what about WPO 1300?
That is a connected matter with respect to this for the same assessment here, your lordship.
What was the challenge in that?
But if I may indicate now the facts, my lord, what has transpired. But what had happened in the matter, my lord, is that reassessment proceedings were completed against the assessee, wherein your lordship, the exemption under section 11 was sought to be denied. Against that, your lordship, the assessee preferred a statutory appeal before the Commissioner of Income Tax Appeals under section 246A of the Act, your lordship. During the pendency of after having filed the appeal and during the pendency of the said appeal, your lordship, the assessee filed a revision application under section 264 before the Commissioner of Income Tax Exemptions. And your lordship, he sought to withdraw the appeal filed before the Commissioner of Income Tax Appeals. Now, my lord, in my humble submission, that cause, in fact, the revision application under section 264 is not maintainable, nor was the assessee's action of opting for a withdrawal of the appeal was maintainable, because your lordship, the Honorable Supreme Court has clearly laid down that once the appellate mechanism machinery is put into motion, it cannot be it cannot be withdrawn, and it cannot be put to a stop by the assessee by way of a withdrawal, your lordship. So having your lordship filed the appeal under section 264 subsection 4 clause C, my revision application was not maintainable. Now, my lord, assessee filed an application for withdrawal of the appeal before the Commissioner of Income Tax Appeal after the revision application, your lordship. Your lordship, that revision application was, that withdrawal application was accepted by the department after multiple reminders and multiple letters. It was accepted by the department, and they passed an order on 7th March 2023 dismissing the appeal as withdrawn. My lord, so the assessee was thereafter advised, like, when the entire matter was being examined by the auditor felt that this entire recourse being, or the entire course of action being adopted as contrary to law. They approached a senior advocate, your lordship, and he advised that the entire course of action being adopted and even this order of withdrawal, dismissing the appeal as withdrawn, is all contrary to law. So accordingly, your lordship, the assessee immediately filed an application before the Commissioner of Income Tax under section 264, informing him of the same, telling him that he would, in fact, his revision application is not maintainable, he seeks to withdraw it, and that he intends to file a 154 rectification application before the Commissioner of Income Tax Appeals. Simultaneously, your lordship, the assessee also filed an appeal before the tribunal, because your lordship, that order for dismissal was already passed. So he adopted two recourses there, filing a 154 application and also an appeal before the tribunal, your lordship. And And an application was also filed before the Commissioner of Income Tax Exemptions that please do not proceed with the 264. It is not maintainable. Now, Your Lordship, what the Commissioner of Income Tax did was that instead of considering my application, wherein I have said that I filed a 154, I will be filing an appeal, and that I do not wish for you to proceed with the matter, he rejects that application, he proceeds with the matter, and he passes an order under 264 on merits. In fact, he deals with it, despite the fact that the assessee had made a clear objection that please do not proceed with it on the basis of the advice. If my lord may allow.
Yes.
And wait,
Please.
sorry,
No.
But the assessment, the order passed by the Commissioner under Section 264 is subject matter of challenge in the writ petition. And the order passed by the tribunal is before my lords in the 260 appeal.
So against in the regular appeal filed before the tribunal rejected it.
I'll just give the background. Against the assessment, an appeal was preferred before the Commissioner appeals.
Correct.
It was filed within time. But after the filing of the appeal, the assessee was advised, in my humble submission wrongly, to approach the Commissioner under Section 264 against the very same assessment. Now, during the having filed the appeal, the Commissioner, the assessee went ahead and filed the petition under Section 264. Thereafter, requested the Commissioner appeals to allow withdrawal of the appeal. Now, the Commissioner appeals also allowed withdrawal of the appeal in the year 2023. At that stage,
so sought to withdraw the appeal before
the Commissioner appeals. But I've got a list of dates.
Yes.
So the appeal withdrawal was allowed in March 2023. 7th March.
7th March 23.
Lordship. At that time, this matter was noticed by the internal auditor of the assessee, the Cricket Association of Bengal, because they thought that something is amiss. There was an appeal against the assessment, then that appeal has been withdrawn, and then 264. So they said that you better seek the advice of a senior counsel because we think that there are missteps here. Because the proper remedy which had been availed, that has been jettisoned, and another remedy has been sought to be adopted, which actually does not lie. So the matter was examined, then they were advised that once the appeal was filed before the Commissioner appeals, 264 did not lie at all.
It's not maintainable.
Not maintainable. So they were actually misguided, and they took the wrong course of action totally. So the advice given was that we should request the Commissioner not to act under 264.
So that was subsequent to the withdrawal.
Yes, subsequent to the withdrawal, the Commissioner, a letter was written to the Commissioner under 264, who was the revising Commissioner, that this is the advice that we have received.
Commissioner of Income Tax
exemption. That this is the advice we have received. We are also approaching the Commissioner appeals under Section 264 because he had no power to allow withdrawal. That is
to restore the appeal.
To restore the appeal. And so please do not decide our 264 petition. The application to the Commissioner was under Section 154 Commissioner appeals. And before the Commissioner, before he passed the order under Section 261, I had made this request. And what I also did was not against the order of the Commissioner appeals allowing withdrawal of the appeal. I preferred an appeal before the tribunal. And that is the appeal which has traveled up to my lords. Because if the Commissioner appeals had no jurisdiction or authority to allow withdrawal of the appeal, so that order could be made subject matter of challenge.
Now, this request made to the Commissioner exemption, not to proceed to 263 was not accepted. He went on proceeded to pass an order.
Lordship, he has noted my request and he's discussed it. He has said that I will be leaving you remediless if I do not decide your 264. Therefore, I am going to decide your 264. So he goes ahead, decides it on merits also.
But as on that date, your appeal before the tribunal was pending.
On that day, I'll just give.
What date the Commissioner in exemption, passed order on in the 263, 264, sorry.
Lord, on 30th March, he passed the order, 30th March 2023. My appeal before the tribunal was filed on 28th of March 2023.
154 and 27. 154 and 27, which was informed.
And the 154 Lord, was filed on 27th March 2023. So, I wrote to the commissioner on 27th. Commissioner appeal, I applied on 27th. Commissioner exemption, I wrote on 27th. 28th, the following day, I preferred the appeal before the tribunal. The commissioner appeals, commissioner exemption, I thought will accept my prayer. But he went and passed the order on 30th March.
But in that communication, you had mentioned that you already moved the tribunal.
No, I had mentioned that I had
intend moving the tribunal.
that no, that I was writing to the commissioner appeal to under section 254, under section 154. That part was mentioned. About the tribunal appeal, it was not mentioned. It was not mentioned. Because that day, I had not filed the appeal. So,
27th, you had not filed.
I had not filed the appeal.
So this 154 application was never filed.
It was filed. 154 was filed.
On what date?
It's 27th March 2020.
Yes.
Therefore, it was a case where assessee was on the right course, took a misstep by filing 264. Then the course correction was sought to be made before any adverse decision was taken. It is not a case where there was an adverse decision and thereafter I was trying to correct the course. Before the commissioner decided the 264, I corrected the course and I requested him not to take it up. Because I need to be in the right forum. I pursue 264, thereafter issues arise, the maintainability questions arise. So I could not take, once having been advised, I could not be taking chances anymore in pursuing the wrong, path that I had adopted in between. So this is how the facts stand. The commissioner, the tribunal seems to take the view that I was trying to ride into both the boats and I was taking a chance in both the forum. It is not like that. I was in the correct forum. On the basis of wrong advice, I approached the revisional authority. Then before the revisional authority could act, I corrected course, and against the withdrawal part, I went to the tribunal so that that part was also I could rectify.
The Commissioner Appeals has not passed any order in the application under 154.
No, there's nothing communicated. And the order on the appeal itself is simple order of allowing withdrawal of the appeal. The appeal.
That is correct. Originally on 7th of March 2023, the appeal was dismissed as withdrawn. On 27th of March, you filed an application at 154. That is kept pending.
That is there.
And on 28th of March, you filed an appeal before the tribunal challenging the 7th of March order.
Lordship.
That is now rejected.
Yes, that is how the 260 appeal.
And the 264 order was challenged in the writ petition, which was dismissed. No.
That writ petition, directions were made. and when the writ court was pleased to observe that the tribunal should deal with the appeal against the withdrawal order. So then that order came to be passed by the tribunal, and then since the remedy was before the Honorable Division Bench, the 260 appeal was filed.
Suppose you succeed in ITA 16,
Lordship.
everything stands restored.
Lordship, I would be, yes, the
Automatically, the appeal had to be decided on merits. Or the tribunal can, or you can argue here that this application for withdrawal itself was not maintainable. Therefore, even on a wrong advice, the assessee had gone before the commissioner exemption, commissioner appeals for withdrawal that could not have been entertained.
So once
But there is no decision on merits.
No decision on merit by the tribunal or by the commissioner appeals. The commissioner under 264 has proceeded to deal with the merits, because once he said that no, I have to decide the 264, he has gone into the merits. But my humble submission,
that application itself was not maintained.
264 itself was not maintainable. Similarly, the course correction should have been allowed.
All right.
Now, in the list of dates, the page numbers are also mentioned. Basically, the documents are in volume 1 and volume 4.
No, first we'll see the tribunal's order.
My lord, can you take note? Volume
We
4.
have got the memo of appeal. It's
Lordship.
easier. It's easier. He goes.
मेरे को बोल रहा हूँ तब स्टेज में फाइल है के पास उस टाइम पे किए थे वरना फटे क्यों इसको निकाल के रखे
There must be another thing I keep.
Admission order.
He has appeared here.
Admission order.
I told. That's why I told Dalapati, give the photograph.
So they will be out of these papers.
तो वो बाकी से जो हमारा एप्लीकेशन है दैट इटसेल्फ इज अ पेपर
ये नहीं
ये सही ठीक है
Yes.
If my lords are pleased to have my lords have that volume formula or the memorandum of appeal.
Memorandum.
Gotcha. The other documents my lords will find in the volume formula. Page, can you see the order of the tribunal dated 21st of August 2023?
Where is the order passed in the writ petition, interim order?
Lordship,
It's expected,
yes, it is, kindly have in volume 4 itself.
volume 4,
I'm sorry, volume 1, page 80. Page 80.
18,
80.
80.
Possibly, these prima facie observations influence the tribunal in its view.
But the ultimate observation was the tribunal to decide in accordance with law.
Yes.
But tribunal non-suited you on the ground that you are neither here nor there, going here and there. And merely because you did not get a relief under 264, you are now trying to pursue this appeal.
But in fact, my appeal before the tribunal was filed before the 264 disposal. I did not know the fate of my 264.
28th of March, you had filed the appeal.
Lordship.
30th of March alone, this was there. In the interregnum, 27th, you sought for deferment of the proceedings.
Yes.
264.
Yes, that letter, my lord, just please to simulate that page.
But the issue is it not covered by TNCA judgment?
But the Honorable Supreme, the Madras High Court judgment, but the matter was thereafter traveled up to the Honorable Supreme Court. But the Honorable Supreme Court has sent the matters back, saying that to look into the facts because these IPL money, etc. So the matters actually gone back.
It's been remanded.
Yes, Lord. So therefore, the commissioner, this requires examination. So it is not a closed chapter, so to say. It requires examination. That examination would happen in the appeal before the commissioner appeal. That was what the assessees.
So by virtue of rejecting the appeal, you have virtually left remediless.
But I am only in the 264 challenge order to 264 in the writ petition. So there, the merits are also there.
That is there, but whether the 264 was maintainable.
That is the larger.
How does the commissioner decide that 264?
Yes.
Maintainability issue.
Lordship, kindly take that order of the commissioner in volume 1 itself. At page 60. The first 6 pages are on this part, where the rest thereafter it's on merit.
Para 3.2.
Malus.
I have to first decide whether an application of withdrawal and to can be acceded to by me. One needs to take facts of this case in detail.
So he sets out my statement of facts and grounds of appeal before the commissioner appeals. That setting out is there. Then at page 63 para 3.4. It could be seen that the relief sought before me is almost identical as sought by the assessee in Form 35 before the CIT appeal. In both the appeal as well as the present revision petition, assessee has challenged the reopening of the assessment as well as argued against the additions made of rupees 18 crore odd. Is evident from a plain reading of the grounds in Form 35 as well as the relief sought in the present revision petition that both are identical in the content and spirit. Section 264(4) states that the CIT cannot pass any revision order if there is an appeal pending in respect of the order proposed to be revised under clause B and C of section 264(4) or subject the time for filing the appeal has not passed, clause A of section 264(4). In the instant case, clause A will admittedly not apply. The application of clauses B and C would have to be examined. As discussed earlier, the assessee had filed an appeal with the CIT on 24/10/29. It should be 2021, which was later withdrawn by the assessee, and the CITA NFAC, through his order dated 7th March 2023, has dismissed the appeal as withdrawn. The petition of the assessee before the CIT appeal withdrawing the appeal and the operative part of CITA order reads as follows. Then he sets out that prayer for withdrawal, and then at page 64, para 3.5. On the basis of these averments, the CITA has allowed the appeal to be withdrawn. In consequence, as the appeal has already been dismissed as on the date of the present order, there is no valid appeal pending before the CITA appeal on the issue. It is also to be noted that the CITA has merely relied on the request of the assessee for withdrawal without discussing the facts or the merits of the case. It therefore cannot be said that the appeal of the assessee has been decided on merits, but in fact, it would have to be held that the assessee has waived his right of appeal. It is thus evident on facts that none of the conditions barring the proceeding with the revision of under section 264 are satisfied. In this connection, the following decisions of various high courts are relevant. Then there's reference to Bombay High Court. I'll place those decisions. Then B, there's a decision of the Honorable Punjab Haryana High Court. On next page, C, there's a reference of the judgment of our court.
But he did not decide that issue whether 264 was maintainable.
He says in para 3.5 that the assessee has waived his right of appeal.
That yes, 3.6 also he says so.
Yes, now he first says that A does not apply, and then he goes on to say that B and C have to be seen. Then he says I have waived my right of appeal, which is actually under A. So I'll place that provision to show.
On what date 264 was filed?
It was filed on 3rd of December 2021.
3rd December 2021.
My lord.
No. But on the date when 264 was filed, appeal was pending before the Commission of Appeal.
It was.
So that point he has not decided.
That he has not decided. He says today there is no appeal. That's what he says.
That as of 30th of March there is no appeal, admittedly.
Yes.
But your contention itself was you were before the wrong forum.
Yes.
And such an appeal filed was not maintainable. I'm sorry, application under 264 was not maintainable.
Okay.
On the date in which it was filed, that is 3/12/2021, because the appeal was pending as on that date.
Yes.
That issue is not decided.
He is not.
The question of waiver, subject to what Mr. Kundali will say, waiver to be tested on the date, which is the relevant date to test waiver.
But my lords are right. But can you also have a look at the statutory language of section 264, subsection 4? Subsection 1 gives that power. Subsection 4 is which prohibits the exercise of that power, the principal chief commissioner or chief commissioner or principal commissioner or commissioner shall not revise any order under this section in the following cases. A, when an appeal lies against the order, where an appeal against the order lies to the Deputy Commissioner Appeals or to the Joint Commissioner or the Commissioner Appeals or to the Appellate Tribunal but has not been made, and the time within which such appeal may be made has not expired, or in the case of an appeal to the Joint Commissioner Appeals or the Commissioner Appeals or the Appellate Tribunal, the assessee has not waived his right of appeal. B, where the order is pending on an appeal before the Deputy Commissioner Appeals, or C, where the order has been made the subject of an appeal to the Joint Commissioner Appeals or the Commissioner Appeals or to the Appellate Tribunal.
So contingency B and C will apply.
But B, C is where our case falls, because C is a case where I made the order subject of an appeal. What happens to that appeal thereafter is of no consequence. The moment I have made it subject of an appeal, the jurisdiction of the commissioner under 264 is ousted.
But what about B?
B, where the order is pending on an appeal before the Deputy Commissioner Appeals.
Oh, Deputy Commissioner.
Deputy Commissioner Appeals.
So C will apply.
C will apply. C is a bar. Once I've made it subject of an appeal.
So these are all because of the expression or.
Gotcha.
So mutually exclusive.
Gotcha. But A is dealing with a situation where the appeal has
not been made.
Has not been.
But that situation is not here.
Our appeal was made. Appeal was therefore the C.
So the question of waiver is spoken of only in clause A.
The reason is where the time to file the appeal is available. Then I should have waived the right of appeal, because it's waiver of the right of appeal. Once I've preferred the appeal, there's no waiver of that right. The right has been exercised.
I think the commissioner was of the impression, because you withdrew the appeal, it tantamounts to waiver.
In my submission, that the section says waive the right of appeal, his right of appeal. The right is not waived, right is exercised. Thereafter,
and such waiver should be unequivocal and unconditional. So, because normally they say, I will accept the order to purchase fees, I will pay this, please do not do that, do this, do this. And courts have held that such request cannot be construed to be an unconditional waiver.
But clause A has been considered also by courts. It has doesn't matter.
So if you apply this 264 petition is not maintainable. Consequently, that order has to go. Then the tribunal's order challenging the order passed by
the Commissioner Appeals allowing withdrawal of appeal. The Supreme Court has said, and also subsequently our courts have followed that view, saying that once the appeal is filed, it cannot be allowed to be withdrawn.
Because it says such other order.
No, that is in any other case. Kindly see section 246, 250, 251. In disposing of an appeal, the Commissioner Appeals shall have the following powers. In an appeal against an order of assessment, he may confirm, reduce, enhance, or annul the assessment. These are the only powers. AA, in an appeal against the proviso I have not placed. AA, in an appeal against the order of assessment in respect of it proceeding before settlement commission abates. Not a situation with which we are concerned. B, in an appeal against an order imposing a penalty, he may confirm. So again, that's a penalty. C is in any other case. So not being an appeal against an assessment. In any other case, he can pass such order as he thinks fit. So as far as because the Commissioner Appeal has the power of enhancement as well. So the assessee having preferred the appeal, it cannot thereafter withdraw it because Commissioner Appeals has larger powers to deal with the matter.
Where is the withdrawal order?
Lordship. But kindly take note the order at page 54 of volume 1. The operative part, my lords, will find at page 58.
The withdrawal was to enable you to process or pursue the 264. Wrong advice.
But even the commissioner, if the law does not allow him to permit withdrawal, he cannot allow it no matter whatever the reason.
What do you say,
But the decisions which support me, I
that
can.
is correct. But cannot the Commissioner Appeals decide the appeal on merits? You are trying to non-suit him. You shut one door, you shut another door. He is completely.
My lord has heard the facts. No, here's the facts from my perspective also. And the facts are that from 2021.
You are not member of this. You will not get tickets next time.
That's true, my lord.
Somewhere they should agitate the rights.
No, that agitation of rights has happened before the revision. That's where they chose.
That revision itself was not maintained.
Now how, my lord? My lord will also consider in what situation this has happened. In 2021, October, they filed the appeal.
24th October.
Then December, they filed the revision.
Yes.
Everyone sat.
October 19, they filed the appeal.
2021.
21.
21, sorry.
Both appeal and revision were filed in 21.
2021, yes.
Right, my lord? Thereafter, everyone sat. Time came when they wanted this revision to be heard. Now, the limitation period for this revision to be heard was till 31st March. They chose the forum of revision. They go before the appeal, before the Commissioner Appeals. They say, I want to continue with the revision. You kindly will allow me to withdraw.
By consent, you can't confer jurisdiction.
My lord, I have some judgments which are in Hardutrai and that line of judgments. All those appeals had been filed at the instance of the Income Tax Department. So prejudice was being caused to the Income Tax Department, not them, not the petitioner. In this case, Income Tax Department is not coming before my lord and saying that this cannot be withdrawn. Petitioner has withdrawn and then says petition has withdrawn because they want to pursue revision jurisdiction.
Precisely for this reason, because there is a statutory bar. Because there is a statutory bar, somebody has advised them, you please withdraw your appeal. Then only the 264 can be taken up.
No, my lord.
That's the
that is something they say much later. The revision, revisional jurisdiction, the limitation period was getting over on 31st March. When have they filed the letter for withdrawal? My lord will kindly see. 23rd February 23 they filed. So this is all a span of 1 month. All this is happening, my lord. 23rd February, if my lord sees page 68, 58, 58, which my learned friend was showing.
23rd of?
23rd of February 23.
Ah.
My lord, you can only see that letter is in page 58, it has been
So
set
first
out.
letter is dated 2nd of March.
The first is 16 November 2022. Lord. It's in my list of
Yes.
dates. First is 16 November 2022. And that was followed up with reminders in
Yes.
February and March 22.
Where is that 16th November?
That is not annexed, but sir, the letter of March is annexed. यहाँ पे वो reference है.
It's mentioned.
Page 535. Volume?
Volume 4.
Volume 4 ही है.
Page 555 में.
Volume 4.
तो यहाँ पे वो
My lord will find out at page 535 in the paragraph in the middle, third paragraph. After enablement of communication window, we have uploaded our written application for withdrawal of appeals in the name of so-and-so on the portal via communication window on the Commissioner Appeals on 16th November 2022. And then there were reminders thereafter.
So after the portal was opened, उसके पहले communication.
So there's a communication on the 6th of March also, my lord. This is at page 535,
हाँ उसी का.
where they say so it's not that they applied for it and immediately it was given. My lord will kindly read this letter. It's very evident. The last paragraph is very interesting, my lord.
So therefore, the department was fully aware that they cannot proceed with the 264
Yes.
because of the pendency of the appeal.
That's correct, my lord.
Therefore, the assessee probably advised to do so. They addressed the Commission Appeals seeking permission to withdraw,
Yes.
which is evident from the next communication
Yes, my lord.
dated 2nd of March, 27th of March.
Yes, my lord. That is a communication by when they had already, the appeal were already withdrawn. 27th March is a communication.
27th of March is for restoration.
Yes.
There are two letters on 27 March. 537 is the letter to the Commissioner Exemption and 540 is the letter to Commissioner Appeals.
Somebody should decide the matter on merits.
The matter has been decided on merits by the revisionary authority.
No, he didn't have jurisdiction. He doesn't have jurisdiction. See, we have to take the date on filing 264 will be the crucial date, not on the date when the 264 was decided. 264 was filed on 3rd of December 2021. On that date, in terms of clause C, 264(4)(c), the application was barred because the statute used shall not.
My lord. My lord.
So let them decide it on merits, sir. Of course, they have to be blamed for that. The principal chief commissioner or principal commissioner or commissioner shall not revise any order under this section in following cases. A will not apply, B will not apply, C will apply. Where the order has been made, the subject of an appeal to the Joint Commission Appeals or to the Commission Appeals or to the appellate tribunal.
Well, there's a decision where the appeal was filed. It was not admitted because the admitted tax was not paid. And with 264 was sought to be availed. Court was please told that once you file the appeal,
it's gone.
It's gone.
My lord, I have a judgment on this point. In fact, I wanted to reply on another. I thought
Not issue.
time.
Better take a decision on merits. And
I still feel that, my lord, the decision has been taken on merits.
that is
Giving
correct.
them another opportunity for something which they wanted. And today they are actually blowing hot and cold because this has happened. Now they are going there. And the commissioner exemptions did not have any other way without passing an order on 30th, because 31st was the last day. They would have,
No.
they were remediless on that day,
But
they would have subsequently been remediless.
But on 27th itself, they have said, sir, please don't pass an order.
Don't pass it. Then, which is why, considering that also, considering Vikas Nagela's case, the commissioner passed an
Where
order
is the
saying
question
they
of
will be
waivers?
remediless.
Where is the question of waiver? Even going by the tenor of the letter,
Yes.
it is conditional, saying that we can't pursue 264, therefore please allow me to withdraw.
Yes.
It is not unconditional, saying that I waive my right of appeal, I accept your 43 crore demand,
No, my
I'm
lord,
ready to pay the
my
entire.
lord, the moment the petitioner says that I want to go through
In all
that particular,
he will not succeed before the CIT.
because 264 is an
Even if it
alternative
is sent
remedy.
back, if they will not succeed before
But
citing TNCA judgment, they will.
my respectful submission is, my lord, 264 is an alternative remedy. If the petitioner chooses an alternative remedy, then
it can't be a substitute for an appeal, sir. Revision can't be a substitute for.
If they themselves want it that way,
Correct, rightly
they have
so.
it's not that the department has done anything. They have themselves wanted it that way.
Department is not to be blamed.
So department from the very beginning has at no point of time, it's not that
In
it
fact,
passed that order easily.
Commissioner exemption was right to the extent saying, if he doesn't pass an order, their rights, they'll be left remediless.
Yes, 35
But
after
before
30 is
that,
gone.
it was incumbent upon commissioner exemption to see whether at all he can entertain such an application.
My lord, will
On the date,
that point of time think
the date of filing the application is important.
date of filing of application was important, but my lord, ultimately when it was taken up and heard, at that stage, my lord,
That before the hearing, they made it clear, please don't hear this. We are seeking for hearing the appeal on merits. We have already preferred an appeal before the tribunal. That was also pending.
no, they didn't say that.
Yes,
They didn't say that it is pending before tribunal.
The tribunal appeal was filed later. I mentioned.
No. They said that they are moving an application under 154.
Correct, my lord.
Which was filed on 27th.
Correct, my lord. No,
So
was the
27th commission exemption?
No, my lord, kindly assesses the situation at that point of time of the revisional commissioner. Appeal, they say that there is no appeal today. They say there is no appeal today, but we have filed the rectification.
They should have not pressed 264. The moment they had filed an appeal, they should have not pressed 264.
Now today they are
such a big organization.
No, my lord. Today they are disturbed by this because the order went against them. The 264 order went against them. If 264 order didn't go against them, would they have come here before my lord? So my lord will also think in that line.
No, the 264 order.
How much rope
Can
will
the
you give
commissioner revise it under 263?
No.
No.
Then the department can file a writ petition against that.
Department can file or file an appeal.
Yes.
Appeal will
Appeal
not.
not made.
Not.
You would have challenged it.
They could have challenged. Sumrat, I could not take.
So it was at our instance. Everything has been done by them. Today, after doing that, after getting an order against them,
they have become wiser, sir. They have become wiser. That's it.
Now, wiser or not, my lord, will kindly see the bona fide of this whole thing that is happening.
Even a hardened criminal conduct is considered. Then parole is granted. This is granted. That is granted. Let them take an order on merits.
My lord will kindly
And
see.
that decision you please.
Relevant paragraph. After that. Kindly see from paragraph 7 onwards. I rely on 7 to 13. In this case also appeal and application filed on the same day. Paragraph 8 says that. Paragraph 10, my lord, is also important.
So here the revision was not entertained.
My lord,
No, in this
no,
case.
revision was entertained.
No, there
Lord,
are
it-
some words missing in para 13.
Yes, it's paragraph 12. My lord, sees paragraph 12. Apart from authority, I would also have been inclined to hold that the SSC had a right either to have his grievance ventilated and determined on merits by the tribunal on appeal or by the commissioner by way of revision. The choice necessary must be only that of the SSC. And if he asks for permission to withdraw his appeal filed before the tribunal and that permission is granted, there is a clear indication that he does not, a couple of words are there, but it indicates that he does not want to pursue his grievance ventilated and determined by the tribunal, but by the commissioner. That right of choice cannot be denied to him any technical or of critical ground, so long as to decision has been given on the merits of even on the question of limitation by the tribunal, the case cannot, in my judgment, be said to have formed the subject matter of the appeal to the tribunal. For the reasons given above, I would direct that a writ in the nature of certiorari will issue quashing the order of the Commission of Income Tax, indicate income tax and gift tax dated so and so, holding that the petitioner's application for revision under so and so was incompetent and with the direction that he will entertain the revision and dispose it of in accordance with law. So direction was given that it should be disposed of in revision.
See, in this case, the facts in para 7,
Well,
on 3rd of May 1960, they made an application for withdrawing the appeal. Apparently on the same day, para 8, application under 24(1) was filed under of the gift tax was filed before the commissioner. On 29th of June, 60 granted the application to withdraw the appeal and dismiss the appeal as withdrawn.
yes. In this case, it is going to their benefit. Petitioner is doing this. Petitioner wants his revision to be.
In this case, the only difference, which is material difference, against the assessment order, appeal was filed on 24th of October 2021.
My lord. Same day he files a revision also.
Revision, he filed it on 3rd of December 2021, which was not maintainable.
My lord, here also same day he has filed. In this case,
No.
in this case, my lord,
In this case, he
Yes.
made an application for withdrawal to the tribunal. Same day, he filed an application under 24(1).
right, my lord, right, my lord.
Tribunal subsequently passed an order on 29 June dismissing the appeal as
No,
withdrawn.
my lord, when does a revision or appeal, my lord sits on adjudication only when the matter is moved, and when the matter is moved, my lord decides whether this matter is maintainable or not maintainable. Does the registrar decide whether the matter is maintainable or
In
not?
my opinion, they should. In my parent high court, there are appeal examiners. They will examine the prayer,
Yes, my lord.
the array of parties, whether such a prayer was maintainable. Unfortunately, here, everything gets dumped. We are here and sitting and scanning through paper how this writ is maintainable.
So in this
So,
case also,
This new jurisprudence developed in Calcutta High Court is police in action.
police action.
Complete CRPC has been given a go by. He files an application before sessions for bail, etc. Nothing is getting through. He may not get it here. Writ petition is filed. Police in action. And virtually it is converted
And
as
that forms the bulk of the writ petitions that are
Ah.
filed in Calcutta High Court.
How is it maintainable, sir? In fact, 2 decisions we have rendered, myself and Justice Kirma Bhattacharya. The third one we are about to pass, they withdrew the writ petition. New jurisprudence.
My lord, in this case today, there's a stark difference in all the judgments that I have gone through. Stark difference is here the mistakes are made by them.
100%.
Themselves say I am making mistakes.
100%.
I want to take benefit of my mistakes. And therefore, the court is there. Court has to follow that.
But court has to see whether
The court has to
as
see,
assessing
my lord.
should not be left remediless.
Now that is exactly what the revision authority thought. My lord puts my lord in revision authority's shoes for a moment. At that point of time, what was there with him? He says, even if he says don't go ahead with the revision, his revision limitation period goes. This was 30th of March. 31st March, his limitation period would have gone to pass an order. So he followed the judgment of this court, Vikas Nagela, which
But
says
before the commissioner exemption could pass an order, he filed an application under 154. He filed an application under 154.
filing of 154, does it mean appeal is there?
No.
Then?
Therefore, the assessee's intention was to pursue the appeal on merits.
Something where he has withdrawn.
Yes.
Where he has withdrawn his filing after a few days, that
He
150
withdrew the appeal on the understanding that unless he withdraws, 264 cannot be proceeded, which is right. Because of the statutory bar, 264 could not have been entertained.
And he goes before the appeal authority and says that I want to prefer that.
Exactly. He says,
I want to prefer that. You let me go. He lets you go. Then he goes there to the authority of his preference and says, no. What I have done is wrong. I am filing a 154. Therefore, you also don't go ahead. Now, what is the fault of the revisioning authority at that point in time saying that you will be rendered remediless because I have only 1 day left for the order? In this situation, if the order was positive in his favor, my humble submission, he wouldn't have come before my lord. कौन सा इसमें कौन सा क्या पॉइंट पे well, there is another judgment I would want to refer. Paragraph 1. No, sir. Sir, I rely on paragraph 8 and 9 of this judgment of the Gujarat High Court, 2018, volume 91, taxman.com, page 196. At the next week, that's my name. And my lord, in the earlier judgment also, my lord has seen what is an appeal. It's abortive appeal. An appeal which is an abortive appeal is not an appeal under law. My lord, paragraph 8 and 9. My lord, will kindly see paragraph 8.
One second. Where is the letter dated 27th of March 2023 addressed to the Commissioner Exemption asking him not to?
Page 537, volume 4.
It's a well drafted letter.
Very well drafted, but this I have answers to this also.
Because the Commissioner says, exemption says it was a case of waiver. Once that's what this Allahabad High Court says. When an appeal is filed, the right of appeal stands availed and exhausted by the SSC. Hence, question of waiver of right of appeal, therefore, would not arise. Wrong understandings. And what did the Commissioner exemptions do on this letter? No reply.
He just noted it, but he says that the assessee has withdrawn.
He also goes to the extent of saying that the commissioner cannot exercise power under 154. There is also
He
one
says-
observation
he says.
saying that it is
In that-
only clerical mistakes he can rectify. He can't recall his order.
No, that part of the law was settled by judgment of the Supreme Court, that once the appeal machinery is set in motion, the first judgment which my learned friend referred to was a case of withdrawal of appeal before the tribunal. Tribunal does not have power of enhancement. The subsequent, the Gujarat judgment does not notice the Supreme Court view.
The concept of enhancement is to the detriment of
Where
the
is that
SSC.
Rai Bahadur
Yes.
Chamaria?
Hardut Rai Bahadur Hardut Rai is one of the main judgments on this.
66 ITR 443.
সেটা দিয়ে দিন, কপি আছে।
At page 449, my lord, 449, the relevant passage, page 450.
Page, sorry sir.
449. 449 was the last paragraph. Going over to the next page, it's a continuing paragraph.
কি বলেছে আর কি?
Commissioner appeal should have rejected their application for withdrawal, saying that it can't be done.
My lord, that also there is one judgment. My lord, judgment. 2018 Supreme Court cases online, Madras High Court 13764. Though it's a single bench. My lord, here Hardutrai was considered, and the relevant paragraph is paragraph 20. You will change? 10 to 13. My lord will kindly, I rely on paragraph 10 to 13, 17, 18, 20, 20 to 22. 10 to 13, 17, 18, 20, 21, 22.
But here the facts were different.
My lord, here if my lord sees paragraph 10, it is seen that against the said order of assessment dated 30th March 2015, petitioner had filed an appeal before the Commissioner Income Tax on January 16. However, the petitioner made a request in writing on September 9, 2016 before the said appellate authority to withdraw the said appeal to pursue the revision petition before the Commissioner of Income Tax under section 264. The appellate authority, by his order dated September 16, 2016, dismissed the appeal as withdrawn in view of the request made by the petitioner through their letter dated September 9, 2016. Relevant paragraphs 3, 4, 5 of the above order are as follows. Facts are very clear, my lord, and very similar to.
No. Here, the contention of the revenue was there is a specific para 12. There is a specific bar under 264(4) in maintaining such revision.
My lord.
Having availed of such remedy, even though the said appeal was subsequently withdrawn, still the embargo made under 264(4) will operate against the petitioner in maintaining the revision.
Yes, my lord. In maintaining the revision. What have you said to?
So on para 15, they say,
yes,
the said order of the first respondent impugned this writ petition is not put to challenge by the revenue, questioning its maintainability.
Right.
On the other hand, the order is challenged by the writ petitioner
only by the assessor.
Only by the assessee.
Yes.
Noted that the revenue has neither opposed the withdrawal of the appeal before the commissioner,
Absolutely same situation.
nor challenged the order of the appellate authority dismissing the appeal as withdrawn.
Yes.
Here
Same
it's a
situation.
converse case.
No. Revenue has not challenged.
Revenue is not challenged.
Not challenged.
They have challenged it.
I have not challenged the withdrawal also. They have challenged it. See, exactly same situation. Now, my lord, kindly see paragraph 20, how this has been dealt. My lord, see 17 and 18 also.
15 also, last 5 lines. Therefore, much emphasis made by the council appearing for the respondents on 264(4) regarding maintainability of the revision cannot have any force. what the revenue either accepted or failed to challenge further cannot be objected to as a first time before this court, that too in a proceedings at the instance of the assessee.
Today, in this matter,
264 an order was passed on merits.
my lord,
The revenue contended that 264 was not maintainable. The court held that that contention was not raised by the department when 264 was decided.
correct, my lord, and since your revenue had also not challenged a withdrawal,
Exactly.
that is this is what I am pleading before my lord. Today, in such a situation, this is what was the finding was this. If they had got this order in their favor and I had come, the revenue had come before my lord, this is what would have happened.
No, if you had come here, you would have succeeded. If they are to succeed now, if you were here and they were successful in 264, you can very well argue on the question.
No, but if I hadn't
would have
filed any appeal, I don't have I had
You
to go
can file
to
a
the
writ
tribunal
petition. You
at
can
that
file
stage.
Department can file.
But
In fact,
in this case, they are saying, since the department did not challenge that, since the department did not challenge, and since this point was not taken while the revision of before the revision authority, therefore it can't be taken today. But it also held, my lord, sees paragraph 20.
But this is a 260A appeal, sir. So we have to see a substantial question of law raises for consideration. Not we are not in a writ petition.
My lord,
so
for a moment, let us forget the writ petition completely. Now, my lord, kindly sees paragraph 21. Kindly sees paragraph 17 also. My lord, with particular emphasis, the middle portion, the question that arises, when can an order be said to be the subject of an appeal? According to Mr. Palkhiwala, as already stated, the order becomes the subject of an appeal only when the merits of the order appealed against are dealt with by the appellate authority. While on the other hand, according to Mr. Joshi, order appealed against is the subject of an appeal when a competent appeal against that order is filled in, which a decision could be given by the appellate authority. Hmm? Huh. My lord, I have that Jagmonda's judgment also with me. If my lord wants to take a look, I can show that judgment.
Which one?
The one that is being referred at paragraph 17.
You please show that. 50 ITR 578.
Yes. Paragraph. Six. And 27. Jagmundas is a Bombay High Court judgment. Specifically rely on paragraph 6, 12 to 20, 25 to 27. कौन पैराग्राफ बोलिए फॉलोवर आ जाए एक मिनट
17, 18 था 15
এটি পড়ছিলাম তো फॉलोवर आ गई तो पढ़ছিলাম
17 पढ़े थे पैराग्राफ
हाँ वो लिखा हुआ था मेरा कहाँ अजय पद सिंह নিয়ে তো আমরা দিয়েছি প্রথম
became better and the senior
But here also, in this case, they have reiterated the same decision that Rai Bodu.
Hardutra.
The taxpayer at his option or at his discretion withdraw the appeal to the prejudice of the revenue because he has got power to enhance.
So prejudice the revenue,
And
that is.
this was a case where the appeal before the tribunal was withdrawn. And there was no power for the tribunal to enhance an assessment. So therefore, they say it is in public interest or for the interest of the nation. So the statute has been mandated like that. So question of permitting him to withdraw the, because that is the settled legal position. sir.
What my lord is reading is Jagmohan Das judgment. Jagmohan Das judgment. Now Jagmohan Das judgment was relied upon by this, in this judgment which I was showing earlier. Pallavi Raja. My lord will kindly come to paragraph 20. CIT versus Rai Bahadur, Hardutra, Motilal Chamaria is relied on by the learned counsel for the respondents to contend that the SSC, having once filed an appeal, cannot withdraw it. But in this case, the appellate authority had permitted the writ petitioner appellant to withdraw the appeal so as to pursue his remedy before the first respondent by way of revision under section 264. Neither the said order of the appellate authority nor the order of the first respondent in entertaining and deciding the revision on merits was put to challenge by the revenue. was-
Therefore,
But
they said
therefore, the above contention of the revenue cannot be sustained.
consequently,
Because the revenue did not challenge, it could not be sustained.
and therefore it held the decision
So,
is
which is
factually
the reason was why? Because it was prejudicial to the revenue. Here in this case, also I have not challenged. I am not coming. I just put myself in the shoes of this judgment. I have not challenged before my lord. I think I am not prejudiced. It's an abortive appeal. My lord read this judgment also in Jagmohan Das. When appeal can be treated as an appeal, if it's withdrawn without hearing of merits, it is an abortive appeal and it can't be treated as an appeal.
No, on what date will you consider the appeal to be an abortive appeal or a regular appeal? The date on which it was filed.
No, my lord. The
That
abortiveness
is
of the
on
appeal.
facts, as on the date of filing the 264, there was a valid appeal. That appeal they could not have withdrawn under law.
On that date,
Yes,
they have withdrawn. They have chosen to
that is
withdraw
an erroneous order.
to not to their prejudice. Not to their prejudice if they have withdrawn themselves. The prejudice could have lied only on the revenue. That is my respectful submission. At that stage, without hearing on merits, if the assessee withdraws an appeal, it is only prejudicial to the revenue.
No, it is beneficial to the revenue. He accepts the assessment.
No, it could be because enhancement is there. What my learned friend is pleading is that once
Similar to this Pallav Raja.
Yes.
You did not object to the withdrawal.
Yes. Exactly, my lord. In that
You did not object to the withdrawal.
Here also we have not objected. We took a decision later on not to challenge.
Moot question here is, I don't know what is this question of law suggested, whether the commissioner exemption had jurisdiction.
My lord will kindly once come to 264(4).
Question O.
First,
264(4).
The principal chief commissioner, or principal commissioner or commissioner shall not revise any order under this section in the following case. This is the date of the order, shall not the date of filing. On that day, there is no appeal pending.
On 30th.
The tribunal appeal is pending.
Pardon, sir?
Tribunal appeal is pending.
Appeal as in before the appellate commissioner.
Or the appellate tribunal.
Before the tribunal also, he has gone only on the point of withdrawal, not on merit.
So withdrawal, suppose they had succeeded before the tribunal, the appeal would have been restored.
On that day, the revisioner authority also did not have knowledge that there was appeal before the tribunal. Even if it was there, my respectful submission is
they filed an appeal before the tribunal on 28th of March. On 30th of March, this person could not have passed an order.
They didn't disclose that, my lord. Even if there was an appeal before the tribunal, that does not fall within this purview of 264(4) beginning. But it says,
or before the appellate tribunal.
The principal, as on date, there was no order. So my lord will kindly read that again. The principal chief commissioner, or principal chief commissioner or commissioner shall not revise any order under this section in the following cases. So there is no, on that day there is no appeal.
The tribunal did not notice that the date of filing the appeal before the tribunal.
No, that did not.
My lord will also kindly see paragraph 21 of that judgment that I was placing before my lord. After 20, kindly sees 21. May I place this, my lord?
Yes.
At this juncture, it is useful to note, my lord, this is Pallava Raja. It is useful to note the observations made by the division bench of the Gujarat High Court, reported in Nitin Babubhai Rohit at paragraph 9. In terms of clause A of subsection 4 of section 264, revisional powers would not be exercised inter alia in a case where the period of limitation for filing appeal has not expired and the SSC has not waived the right of appeal. This is essentially to ensure that at the hands of the same SSC, a single issue does not receive consideration at the hands of two separate and independent authorities, one exercising appellate jurisdiction and the other revisional jurisdiction. Applying this principle to the facts on hand, we find that the SSC had clearly made a choice to persuade the Commissioner of Income Tax to exercise his revisional powers under section 264 of the Act and not pursue his appeal before the appellate commissioner. The revisioning authority therefore correctly proceeded to decide the revision petition of the SSC and on facts correctly allowed the same. This later observation needs no elaboration since the order of the commissioner is self-explanatory and eloquent. The SSC had made full disclosure of the capital gain tax, etc., my lord. Likewise, the Allahabad High Court, in its decision of Ajaypat Singhania, which I placed before my lord, has observed as follows: apart from authority, I would also have been inclined to hold that the SSC had a right either to have his grievance ventilated and determined on merits by the tribunal on appeal or by the commissioner by way of revision. The choice necessarily must be only that of the SSC. And if he asks for permission to withdraw his appeal filed before the tribunal, yes, might be tribunal, but the principle, my lord will look into the principle in this case. He has chosen, my lord, tribunal, and if he asks for permission to withdraw his appeal filed before the tribunal, and that permission is granted, there is a clear indication that he does not want his grievance ventilated and determined by the tribunal, but by the commissioner. That right of choice cannot be denied to him on any technical or theoretical grounds, so long as no decision has been given on the merits or even on the question of limitation by the tribunal. So my lord, here
we are not in a contingency under sub clause A. We are in clause C.
My lord,
264 4C. But
that has also been covered, my lord. The judgments I have placed, they have looked into that aspect, my lord. 264, I'll just.
But if he is statutorily prohibited from withdrawing, can an order of withdrawal be given a seal of approval?
Well, statutorily prohibited.
A court cannot grant an order of a seal of approval to an order which is a nullity.
If that is
void,
if that is what my learned friend is pleading, then in no judgment has it been said that it has been wholly barred from withdrawal. Only barred from withdrawal if it causes prejudice to the revenue.
It is also well established that an assessee having once filed an appeal cannot withdraw. In other words, the assessee having filed an appeal brought the machinery of the Act into working.
That is in her
cannot prevent the appellate commissioner from ascertaining and settling the real sum to be assessed by intimation of his withdrawal of the appeal.
That is what was the principle that has been given by Hardutra. So subsequently, the judgments that I showed, my lord, were subsequent judgment where there are situations which I placed before my lord where appeals have been withdrawn. The revenue since the revenue has not challenged at that stage, revenue could not challenge it at the revisionary stage. So all these judgment, Ajaypat Singhania, then Pallavi Raja, then the other judgment,
No, Rai Bahadur so-and-so, that was delivered on 7th of April 1967.
My lord.
Much after the Bombay High Court. In Jagmohan Das.
The Pallavi Raja is later, 2008.
Pardon?
These judgments are later.
That was in 1963.
No,
Yes.
Pallavi Raja is 2018, my lord.
Pallavi Raja is a single bench, sir.
Pallavi
issue-
Raja is 2018, my lord.
But that didn't decide this issue. See, that went on the ground that the revenue, having not objected, cannot at this stage, for the first time in a writ petition, raise the objection. That was not the issue. That is why they say that this decision in this Rai Bahadur is distinguishable on facts. That's how the learned judge holds.
Yes, I am also trying to do exactly that. I am trying to distinguish the facts
But,
here in similar fashion, my lord. Today, my lord again looks into the facts. Under what situation he has done it. At his instance, everything has happened.
Correct.
At every
That-
point
that
he
is
has
not-
done it.
That is not in
He comes before the revisionary authority.
All right.
On
He has made a wrong concession. You ask the court to give a seal of approval?
no, Nagel, my lord will see Nagela then once. Vijayapat Nagela.
If you have accepted it, well and good.
Sir, Nagela का copy नहीं है extra मेरे पास. Nagela parable. My lord, you see, this is a judgment passed by this court.
Para 10.
Para 10, madam.
9 and 10.
Yes, madam. If not being adequately advised is something which my learned friend has been submitting.
But this was also an appeal before the tribunal.
My lord. My lord, even then the principle doesn't change, my
No,
lord.
the principle does change. Does change. Because the tribunal has got no power of enhancement. You may say that you are not aggrieved.
My lord, again, let me go one last time on the facts. And today, when the matter came before the revisionary authority, I will kindly bear it in mind, at that point of time, there was no order. There was no challenge on merit, no order, no proceeding going on. The date was 30th March. 31st March was the last date by which the order had to be passed. Otherwise, they would have been completely, at that stage, they would have been completely non-suited and remedialess. At that state, at that situation, they say, no, I don't want to go ahead with this.
All right. You keep aside all those facts. As on 30th, when he passed the order, was the appeal pending before the tribunal or not?
As on 30th, yes, but he did
Then
not.
class C gets attracted.
But then even if appeal was pending before tribunal, how does it help him?
No, continuation of the proceedings. No, you suppose the tribunal
Then
comes to a conclusion, had come to a conclusion
Right.
that the order permitting withdrawal of the appeal as withdrawal of the appeal and dismissing it was erroneous.
Correct. My lord, if now
So that issue was still at
correct. Now,
large.
my lord looks at it this way now. Revision at that point of time, based on that, revision let go. He says, I'm not going.
He should have taken note of the fact
The
that-
tribunal is there. I'm not going to entertain this jurisdiction. I'm giving up the revision jurisdiction and dismissing the application. In that situation, would that inure to the benefit of this client, this petitioner? My lord, will kindly read 264(4)(c) once again. There are two different orders that are being spoken about. It was
But in the letter dated 27th of March,
my lord.
the associate has not said about the pendency of the appeal before the tribunal.
Yes, not
That
disclosed.
appeal was filed the next day. This letter was submitted on 27th March.
28th appeal was filed.
Yes, it was filed the next day. Governor, the commissioner.
No indication was also given that we are filing an appeal.
But as on the date when the commissioner passed the order, appeal was pending.
No, and this appeal is also served on the department there in the tribunal. It's not that the department is not in the know of the appeal. Once
It's
it
in
is,
the date of filing.
once it is filed, no, they serve a copy on the department.
So what is that, sir?
My lord.
No, my lord, my respectful submission to that is,
Copy देना पड़ेगा. तभी
even if there was an appeal before the tribunal,
and it is
still the revisioning authority could have only two choices. One, based on that, rejecting the revision application.
service etc.
The other one, to decide on it on merits.
No, or defer the hearing or decide on it.
Couldn't have deferred the hearing. 31st was the
31st
last
time
day.
bar.
Yes, time barred. That's exactly what I'm trying to point out, my lord. He couldn't have. My lord will now look at it in a different way for a moment. All this hectic parley and activity that happened between 27th to 30th, why did it come into those dates towards the end of the revision limitation period, time barring period? Look at for a moment before being lenient towards the petitioner, my lord. Kindly understand what is the situation that arose due to which this has happened. Was it merely advice? Can it be merely senior advocate's advice?
No, see, senior advocate didn't
Today
advise
they
to
themselves
file
decide.
264. The senior advocate advice was you did the wrong thing.
What you are doing is wrong. So that, no, my lord will kindly, it started from 21. The same people filed the appeal, the same people filed the revision. They waited and waited. Whoever is better, I will go before him. Whoever is better, I will go before him. Then somewhere or the other, something went wrong. Forum choosing was not very beneficial. This I'm saying from the bar. I can't say this otherwise.
We can't.
But this is, it is palpable. It is palpable here. It is absolutely palpable. He went to withdraw. It was withdrawn. Before withdrawal, the time period was that around January, February. That period had come in. The March limitation period was there. At those parleys happened at around that time. One, they filed the withdrawal. When have they filed the withdrawal, my lord? Then when they have gone and filed the withdrawal of the rectification, 154. All timelines, my lord, will see their own list of dates.
Correct.
My lord, will see their own list of dates. List of dates. See, my lord, September 24, 2021.
On 27th, they did not tell in that letter. Next day, they have filed the appeal.
September 2021, they filed the appeal. October 24, 21, they filed the revision. No, October 24, they filed the appeal. Then they filed the revision December.
24th October 2021, appeal before CIT appeal.
And then while the appeal was there, they filed the revision.
Yes.
So all these aspects, whether both appeal and revision can lie together or not, did not come to their mind. They kept both those things there to be used at an opportune time. At an opportune time, they decided to withdraw.
But was it brought to the notice of the tribunal about the date of filing the appeal before the tribunal.
But that is on their record.
On record.
I'll just, if that is in the part of the record itself. The,
36 I can show a copy, so that's in the writ petition.
But the tribunal did not decide that issue.
no, it did not.
Whether at all the 30th that 264 order could have been passed because of the pendency.
They were basically against the appeal was against the order of the Commissioner of Appeals. The 264 order was under challenge before the Honorable High Court in the writ jurisdiction. So therefore they only looked at that part, the Commissioner of Appeals, whether he could have allowed withdrawal or not. They were really on that note. Of course, they have made observations about the 264 also, but this part, as my lords have observed, they have not.
All right, we'll continue.
My lord, will my lord continue today or next day?
Next Monday or Tuesday.
My lord, Tuesday if it's convenient.
Today would
My
be.
lord is not sitting.
Oh, my lords are not convening again. Then Tuesday.
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 You have heard so and so for continuation of arguments. Tuesday. Immediately after fresh cases. Tuesday will be 17th.
Great.
Service appeals item number 8.
Item number 8, my lord. Okay, for the writ petition respond number 1, my lord. But there are 4 more appeals, 3 more appeals, my lord. So what I say, my lord, let this appeal go out of the list for the time being. Well, I am the sufferer. I am not enjoying an interim order. Nothing has, no contempt is pending before the court. You know, by agreed by a order of the single bench, my lord, the one of the respondent as well as me, we filed 2 sets of appeals.
The other appeals we have released it because of his ladyship was part of that when she was Registrar General. Huh? Oh, Registrar Citizen. This is different matters.
This is a different matter. Well, there are 3 more appeals. I have my 2 appeals. Here I am a respondent. The registrar has
What do you
filed
want now?
Well, let this. I am the respondent. Nobody is there for the petitioner, for the appellant. My lord. Let this matter for the timing go out to the list. When I will be mentioning my matter, I will mention the 4 matters together.
Instead, you give the numbers. We'll club.
Last time, I give the number. Today, I don't have the numbers.
So during the course of the day, you give before 4 p.m.
That I can do. What is happening? I am not enjoying an order. My clients are not that well to do. He's not pursuing it. That is what I was saying. No,
we will just adjourn it. On the next date, let us see who appears for the city's.
Last day also nobody appeared. Nobody is appearing.
Petition.
I'll be starting the arguments. It's my writ petition. I have got an order, my lord. Some little protection, my lord, but still I'm not agreed with the order. My appeal.
None appears for the appellant. Even on the earlier date, namely 21/5/2025, none appeared for the appellant. The learned advocate appearing for the respondent.
Number 1.
Number 1 writ petitioner submits that there are 4 other appeals.
3 more appeals.
3 other appeals, and prays that the matter may go out of the list with liberty to mention. Let the matter go out of the list with liberty to mention to the council on either side.
The art number 8. Item 8.
Item number 9.
Lord, I am for the petitioner.
Lordship, I am playing for a not today because respondent appearing for counsel appearing for respondent number 8 is before another division bench. Honorable division bench. He is in a hearing. It will continue for a considerable time.
Let us see the previous order.
This is a matter where defalcation of nearly 10 crores have been surfaced at the instance of the West Bengal Transport Corporation in a tender matter, giving tender to an outsider.
This is a public interest. Sir.
Yes, public interest.
Oh, okay. You show the order? Assignment order.
My lord, I am appearing for respondent number 227.
But in this case, my lord, the tender was regarding renewal of tram track with concretized pavement along Arjikor Road. But there was an e-tender being floated. That e-tender was participated by 3 participants: Adhunik Construction, Ganesh Iron and Works, and Shubham Enterprises. But that tender was closed down or made redundant because there was no minimum bids received. Second e-tender was issued on the same amount, 8 crore 35 lakhs, 8 crore 38 lakhs. In that tender, two person participated. One is Adhunik Construction, another is Ganesh Works. But the Ganesh Work was not the lowest bidder. Adhunik was the lowest bidder. Work was given to Adhunik. But the bills were raised by both Adhunik and Ganesh Works. Ganesh never participated. Work order was issued by the West Bengal Transport Corporation in connivance with the Finance Department, Government of West Bengal, allotting the job to Adhunik Construction plus Shubham Construction. Shubham never participated in
But
the.
you have not implemented those two.
But the persons who had issued the work order.
No, you should have implemented those two contractors.
Kindly permit me to add Ganesh Construction as well as Shubham Enterprises as the party respondent to the.
My lord, the maintainability point was, my lord, raised on the last occasion by my learned friends, senior, my lord. My lord, even I raised the point of maintainability because the petitioner is was one of the employees of the corporation, and my lord, he has personal vendetta against the corporation. There are number of
Taxpayer. I may be an ex-employee.
There are number of litigations which the petitioner has filed against the management, my lord. Disciplinary proceedings are pending.
No. How did you get all these documents?
But these are all on the basis of.
My lord, it is there in the writ petition. I'll show. He was an employee, and he says that I have in my possession more than 50 documents which will show that there are
documents are available from official.
My lord,
websites.
these documents.
Wait, madam.
My lord.
Documents.
Are you an employee of this company?
Yes, was an ex-employee.
Ex-employee. What was the disciplinary action taken against you?
My lord, disciplinary action was taken that there was an order for carrying out for making me transfer from one depot to another depot. That was not being carried out. So a disciplinary proceeding was initiated, which was challenged held guilty by the disciplinary authority by demotion of one post. Appeal was preferred. In the meantime, I retired. So their disciplinary proceedings comes to an end when there is no employee relationship subsists, and
So
there is no provision in the
no-
service rules also for continuance of the disciplinary proceedings.
Therefore,
after
there
my
is a tinge of personal interest.
supervision. May I just indicate to your lordship?
My lord, not
There are
only
two things
this.
are there, my lord.
My lord,
Firstly,
if I may, my lord.
I am a citizen. I am a taxpayer. The public money to a tune of 10 crores have been defalcated.
Rightly so.
Thirdly,
Had you not been an employee of the corporation, of the tram company, you would not have had access to all this information.
no, I got all these documents by the virtue of RTI and from the official website of the West Bengal Transport Corporation. It is not a document that I have procured from the desk of some person against extraneous gains. I am an employee. I may be an employee. But that doesn't mean that I have procured any with any malified intention. All those documents I have procured by virtue of an RTI application and other documents which have been annexed with the writ petition from the official website.
My lord, the management threatened, advocates threatened. And it is on record. Even the advocates have been threatened by the petitioner by way of letters. That is there in the record, my lord, in this PIL. Managements have been threatened. The authorities have been threatened. My lord,
to safeguard the defalcation.
No, there is absolutely no defalcation. There is nothing.
The work was never been done.
The entire writ petition is on the basis of surmises and conjectures.
From the official custody of the West Bengal Transport Corporation and disbursed.
We have heard the learned advocate for the petitioner and the learned advocates appearing for the respondent. If the learned advocates for the respondent have raised the issue regarding maintainability of the writ petition on the ground that the writ petitioner is a disgruntled former employee of the West Bengal Transport Corporation. and certain records which have been made part of the writ petition were have been in possession of the writ petitioner, and that those records have been utilized for the purpose of filing the present writ petition styled as a public interest litigation. The petitioner further it is submitted, therefore it is submitted that the writ petition is not a genuine public interest litigation. Along with the writ petition, in the stay petition, annexures have been filed. According to the learned advocate for the writ petitioner, the documents were obtained from
on the basis of RT application and official website of the West Bengal Transport Corporation.
Right to Information Act by filing an application, and other documents are available in the official website of the respondent. Let the writ petitioner file an affidavit clearly setting out which are all the documents which are filed as annexures to the stay petition have been obtained by filing applications under Right to Information Act, and which are all the documents he has downloaded from the official website.
Right.
Apart from that, the petitioner has stated that defalcation has been done by two of the contractors as well, who have not been implemented as a respondent in the writ petition. Let such affidavit be filed within 2 weeks from date. Advance copy be served on the learned advocates appearing for the respondent. Liberty to file a reply within a week thereafter. Give a date after 3 weeks. You stop with this.
May I file my affidavit of service, my lord?
What is that lady?
Before your lordship rises, my lord, item number 15 of the appellate side list, this requires to be released because her ladyship was the deponent before the honorable single bench.
And it may be assigned, my lord.
Yes, the other one has been assigned.
Yes, well, this may be assigned also.
Item 15 of the appellate side list.
My lord, may I have your lordship's kind leave to mention item numbers 12 and 13 from your lordship's original side list, my lord. My other side is here. My lord, I'm being led by Mr. S.N. Mukherjee in this matter, my lord. He's in some difficulty. If your lordships may kindly keep it next Friday, my lord.
Malad, that
Well-
is group 9 matter, Malad. That is
Yes.
my appeal, your lordship.
12 and 13.
পাঠাত করেছিল কি?
Friday's senior counsel is coming from Bombay. Already it's fixed.
The group 9
My lord,
পাঠাত আছে
my lord will keep
15.
Malad, that is my appeal, Malad. That is group 9 appeal now, your lordship. So if lordship is pleased to Malad mark it as Pathad, your lordship.
What date he is coming?
very well, my lord.
Oh, group 9.
Malad, that is group,
Yes.
yes, Malad. Those are my appeals. These are group 9
No,
appeals.
Malad,
If
will
lordship
kindly-
marks it as Pathad, your lordship.
Yes.
It's parted.
Malad. Malad.
My lord, your lordship had admitted the appeal, formulated certain questions of law. My lord, GA3 is a separate application filed by the CBI who wants to intervene in this appeal. My lord, I am appearing for the
Then
respondent.
if you don't have determination, we can't consider that application.
My lord, will kindly keep it in your lordship's list, my lord, for next Friday or any other day, my lord. My senior, my lord,
All right.
he will
let
come
it
and
remain
address
in
your
case,
lordship.
don't mention.
Lordship.
My lord, I am appearing for CBI.
Sir, there is a case Matshood where I am not the respondent. The trial court is, please see this trial court is giving pressure to continue this case. It was filed at Alipur court. Once this case was stolen from High Court. Now this is this case is pending before the trial court. I have there is a order passed on.
But what do you want me as?
I have I against that order. I have filed this case. Now this case is released from court number 6. My request to you.
Oh, it has been released.
Yes, sir. This is
Whether the order has
sir,
been uploaded.
It is released to this. My request to you, please you see the matter very. I am in very clear.
Definitely. As soon as the order is uploaded, we will call for the case file and I will assign.
I am requesting you see this matter either or you send this code to 17, please. Or
Let-
17 or you see this matter, sir.
All right. Let the order be uploaded. I'll see.
My lord, item numbers 12 and 13, your lordship is keeping it on, my lord, next Friday or any other day, my lord.
It will be in the list. That's it.
Very well.
My lord, item 15, my lord, a formal order is required.
Yes, formal order passed.
Appearance will be there.